If you thought goldenly breaded McDonald's chicken couldn't get more golden, think Golder, because new sweet and smoky special edition gold sauce is here. Made for your chicken favorites at participating McDonald's for a limited time.
Wish you could become a morning person? You know the type, up before the sun, early morning runs, first one to the office with donuts and a smile. How do they do it? Easy. With the new Galaxy Watch 8, sleep tracking and personalized insights from Samsung Health help you improve so you can wake up to a whole new you. One who, dare I say it, skips the snooze? It's possible. Train your sleep with Galaxy Watch 8. Learn more at Samsung.com. Requires compatible Samsung Galaxy phone, Samsung Health app, and Samsung account.
No, that's not. I'm not going to accept that. I need to know who you talked to.
We talked to her and her husband. On top of that.
Wait, you talked to her and said what?
This is the plaintiff, Audrey Sands-Coulott. She says she purchased a large dining room table and chairs so she could have Thanksgiving dinner at her house, and she still hasn't received all the chairs. She started complaining and was told her salesman made a mistake, and there were only 6 chairs in the set instead of the 8 she purchased. She doesn't give a rat's foot he made a mistake. She paid for 8 chairs, and she wants 8 chairs or her money back. She's suing for $750, the amount she's due. This is the defendant, Alex Yushavayev. He says the set the plaintiff bought was advertised with 6 chairs and displayed in his store with 6 chairs. The plaintiff and her very aggressive sister came into the store and started a big scene, demanding he give her 2 more chairs. Bottom line, they delivered the set and the chairs. The plaintiff signed for it, and she knows the truth. He's accused of shortchanging a customer. The defendant has filed a countersuit for $1,168.63 for loss of time, work, and the remaining balance owed.
All parties, please raise your right hand.
What you are about to witness is real. The participants are not actors. They are actual litigants with a case pending in civil court. Both parties have agreed to drop their claims and have their cases settled here before Judge Marilyn Milian in our forum, the People's Court.
Be seated. Come to order, please. Litigants have been sworn, Your Honor.
Thank you, Douglas. Audrey Sands-Coulott, you are suing Home Elegance Furniture, represented here by the owner, Alex Yushavayev? Yushavayev. Okay. For $750 that you say you will have to pay now to obtain 2 chairs that they promised you and didn't deliver. You have a counterclaim against her because she's wasting your time. Okay, let's go. What happened?
Your Honor, I was visiting my sister in Brooklyn, and I told her I wanted a dining room set. She has very elegant furniture, and I knew she would guide me the right way. So we went into her store. I saw some things. The one particular dining room, it was sturdy. It wasn't elegant, but it was sturdy, and she encouraged me to get it. It consists of a total of 8 chairs, 6 side chairs and 2 armchairs.
Do you have a contract?
Yes.
Show me the contract. Go ahead.
The delivery came in pieces. I got 3 separate delivery. After I see...
No, go back. 3 separate deliveries on what days?
The dates, exact dates, I'm not sure of. I think May 11th was the last delivery.
Do you have any paperwork that shows when the deliveries occurred? And how they were delivered?
She got a delivery date on the 25th.
Everything at once?
Yes.
Okay.
Your Honor, they came 3 times.
Okay, can you show me the paperwork from each time they came?
I don't have paperwork for each time that they came.
Okay, and according to you, they came 3 times and delivered what the first time?
The first time, the table and 2 chairs they assembled. The second time, they assembled 4 other chairs. And then I was waiting.
But when you say assembled, did they deliver all the chairs at the same time as the table, yes or no?
The boxes were there, yes.
Okay.
And I realized that I wasn't seeing 2 more side chairs. I kept calling and calling the store.
You expected 6 side chairs and 2 armchairs?
Yes.
Okay.
I kept calling, and they would tell me that the salesman, which is him, is not in the store. Eventually, I went into the store, and I saw him in the store with the manager, not him, an older gentleman. And they were very, very mean and rude to me. I wasn't getting anywhere with them. I even had to call the cops.
And that is because, according to you, you bought 8 chairs.
A total of 8 chairs, yes.
Okay. Now, you were the salesman.
Yes, I was.
What is this?
What it is this. When we set up, I will also have some evidence I wanted to show you here on my phone. What it is our computer, when we actually set up the ticket, everything I want to show you whenever you get a chance.
No, first talk.
Okay.
Why, your contract says 8 chairs.
Yeah, my contract says 8 chairs, but the whole thing is that when she first came in, I worked out a deal with her, okay? Then we set up the ticket. You have a bracket on the computer to hit either 4 side chairs and 2 armchairs or extra chairs, okay? Myself, I made a mistake.
Okay.
I made a mistake. So
Okay.
what happened is we never discussed it. We never discussed extra chairs, never at all. So what happened is this. After we went through with the order, we worked out the funds or whatever, we always call the customer to verify the customer's there and the product and everything else. Before that happened, the girls from the office called me and said, hey, listen, you have 6 instead of 4. We always usually sell it with 4 side chairs and 2 armchairs. Okay, I have a picture of it being here.
No, you're like dancing all around the topic. Did you sell her 8 or did you sell her 6?
No, I sold her 6.
And when you discovered, you say, no, Judge, I sold her 6. I made a typo, and then the women in your office brought it to your attention.
Yeah,
then what? Then what did you do?
So then what we did was I discussed it with them.
Who's
discussed
them?
this with the customers. It was already discussed with the customers.
No, that's not. I'm not going to accept that. I need to know who you talked to.
We talked to her and her husband. On top of that,
wait, you talked to her and said what?
And her husband
and
about
said,
the chairs, because at this point,
said what?
We discussed that the mistake was made already. And then after it was being delivered, after the chairs were being fixed, I have a discussion here with her and her husband. They're asking me prices after I showed them the way it was displayed with the 4 chairs and the two side chairs. When the 4 side chairs and 2 armchairs, the pricing.
What he's trying to say is the customer.
What he's trying to say, listen. Your company screwed up. She wants to take advantage of it.
Yes.
Yeah.
Right. I got to figure out which you guys should eat your screw up. Okay, this is not rocket science. I'm kind of surprised you don't just do it. But you're trying to tell me that before the delivery, you've got it clear and you've got it in text. It's kind of weird, but let me see the text.
They're asking me the pricing of the next 2 chairs.
But that's because you're telling them, hey, you got to buy 2 new chairs. Look, if there is no meeting of the minds for 8 chairs, and you guys did not screw up, it's just you screwed up. Do you have an off button? Do you hear me talking? Okay. All right. If you sold her 6 chairs, she damn well knows you sold her 6 chairs. That's all she bought were 6 chairs. And then you put in something wrong, then she doesn't have a contract for 8 chairs. But she's not saying that. She's saying, I bought 8 chairs and you screwed up. In other words, you sold her 8 chairs and then somebody else says, whoa, I don't think you meant to do that at this price point. And then he's mad because you sold her 8 chairs. And then she's saying, I want my 8 chairs. No, I got to figure out I know you say no. And she says yes. No, yes, no, yes. You people are always fighting and putting me in the middle. Oh, wait, that's what I'm supposed to do. I've got to figure out which of those 2 scenarios.
I understand.
You see what I'm saying?
Can I show you all this? Proof. We have other proof. When she made the last payment, this was already changed. The computer tells you here how many chairs that she's paying for at the same date she made her last payment.
No, I don't need what you guys can fix on your computer. I need the communication.
That's a shot of the computer screen.
Just a moment. All this is July 6th. When is the delivery of the furniture?
May 27.
What happens between May 27 and July 6th?
They were satisfied,
because that was done with the office.
The text shows that they're inquiring to purchase some more.
The text shows it's July, and the text shows she wants 2 new chairs, and you're texting her husband. She's a customer, guys.
Yeah.
Okay? She's a customer. You're texting her husband. Probably because you found him more reasonable than her.
No,
and you're-
she's a very nice lady. It's the sister that's the aggressor. That's
Oh, the sister. Wait, that sister?
This is why we're here. Miss Audrey's a very nice. She's a very
What do you
nice
mean
lady.
the sister's an aggressor? What do you mean?
They came in. The sister brought her daughter, or Miss Audrey's niece came in.
Okay.
They came in, made a big scene, and at one point she said, her sister said, the niece said, do you want to hit me or hurt me or whatever? And it escalated.
Welcome back to the People's Court. Harvey Levin here. So the contract says 8 chairs. Does the defendant have to deliver 8?
Absolutely. Contract says 8 chairs. Defendant should.
Defendant saying it's a typo.
Then a typo cost him some money, I guess.
Any defense here that, oh, I didn't mean it, it's a typo?
Yeah, the customer's always right, so he would get it.
I guess you could say the defendant doesn't have a leg to stand on. I'll be here all week going inside the courtroom.
What happened there? Tell me about it.
He said it's a Mother's Day special and he's going to give us it for $1,900 with no taxes.
No taxes?
Your Honor, he even circled here
No
and
taxes.
he wrote cash.
Let me see.
He wrote cash. If I give him cash,
I was
it's going to
there.
be just $1,900.
Oh, we got to cheat
She
the
said-
tax man. Okay.
What I did. Oh, can I?
Table size 6 chairs, 2 on. Oh wait. So
Yes.
you're handing this to the customer and she's signing it and it already says the 8 chairs.
You see?
Okay, at this point.
So this isn't something you
this is-
accidentally put in by mistake after she left.
That's the very first time that she came
Yes,
in. If you look at the
I
payment.
know. What am I supposed to do with that?
That's
when
the
you-
first. That's
Yeah, I
the
know.
first payment that's
Yeah.
made. If you look at the first
Yeah.
payment.
Yeah.
On top of that, the thing
Yeah.
about the taxes is, I asked her how is she paying.
When
she
did
said,
you decide to change it from 8 chairs to 6 chairs?
The day of the second payment.
How do I know
That's-
that?
That's not
Because
true.
it says
They say it's not true, so
not
prove
true.
It's
it.
there. It's there. It's in front
Where?
of you right now.
Where?
It's in front of you, it's in front of you right now.
I'm looking at it. Where?
The other paper.
form. The
What
other
other
form.
form?
Screenshot.
Oh, no, that's a screenshot of what? Honey, I'm not
never
stupid.
seen
That's a
it. But
computer
it has
screenshot
the
of your
date.
software. You can type whatever you want in it.
if you
I
look at
can't.
the-
Look, guys,
Okay.
stop. This is simple. You screwed up. Why does a customer have to pay when you screw up? Sometimes just you got to pay when you screw up. But what I don't understand is why would you want to be dragged into court like this when you guys screwed up and you admit you screwed up? And the only thing you can do, and that side is testifying, no, Mother's Day special. That side leaves with something that clearly says 8 chairs. You say, oh, well, look at the text. It's obvious we're discussing prices. No, you're talking to the husband, not your customer. Okay?
Both of them are
And
talk-
stop it. And you're telling the husband, who was never there for the purchase, you're telling the husband, the price, I'll knock it down to $190 a piece for you for each chair. And all he tells you is, I'll get back to you. And then he says, my wife is not satisfied. Call my wife. That's what he says. That's proof of what? What I want to see is some proof that before the delivery you straightened out a mistake, that she accepted. Stop and listen to me, because you're not listening. That she accepted, oh, yeah, you're right, because that would prove to me that they're liars about a Mother's Day special, and they're liars when they say they thought they were buying 8 chairs. So all I need from you is a very simple request. Prove to me that you had some communication with this client to fix your... No, I'm not done with my question. To fix your screw up. See, you can prove that so many ways. Prove, not flap your gums, prove. One way you could prove it is showing me the email you sent them before delivery, making it all clear. One way you could prove it is a message they might have left to you. Another way, apparently, because you know how to text, is a text before delivery. See, if they actually said, oh, yeah, we know it's 6, and then accepted delivery, then you got something here. But you don't have that. You don't have that. They have a contract where it says 8 chairs. Sometimes you just got to eat your own screw up.
Judge, this is how
Guys,
she paid by cash.
$750 verdict for the plaintiff on your counterclaim for your loss of time from work. I guess it's obvious, 0.
All right, so it's no sale for the defendant here. With Judge Milian, what's your reaction to not bringing the proper evidence into court to prove your case?
Mine is honesty. Honesty. That's my big thing.
Honesty's good, and proof is even better.
There you go. I understand.
Thank you. Well, why don't you have an email or some kind of proof of communication, as the judge asked for, between you and this plaintiff, that you corrected your mistake?
The reason why is because I don't have a phone record of of the business's phone. I don't can control.
We don't
what
have a
I
telephone recording of the conversation.
Well, maybe you've learned your lesson to put it in writing. Once you get an agreement like that, that corrects a mistake, you put it in writing. Good idea or bad?
Just like she said, if you can change something on evidence, you know, versus a moral situation of you talking.
Good or bad idea? Get it in writing once you correct the mistake.
I'll take care of it. I'll fix it.
All right, head right down this way. All right, so come on in here and tell me you got your chairs or you got your money. Here, step on in here. You satisfied here? What do you think happened?
I'm satisfied. You know, I have my receipt. It has what I paid for, and I'm just glad that the judge see everything.
You had a big problem here, they said.
I think the judge was fair.
Yeah? What about being the big problem? What about that?
They were pushing her around, so I stand up for her. That's it.
Oh, you started to push them around a little bit?
But that's the truth, you know. I speak the truth. That's
Okay,
why.
all right. Over to Harvey then.
You know, if a mistake is obvious and just grossly unfair, then the judge can say, look, I'm not going to enforce it. That is not the case here. That will do it for this case. Litigants for the next case on the way into the courtroom right now.
Vitamin Water Zero Sugar has great taste, zero BS, and obviously zero sugar. For those with zero room in their calendar, zero patience for slow walkers, those who get 0 hours of sleep on a Saturday night, have zero filter, zero given, and zero interest in grabbing a plain, boring water. Grab a delicious Vitamin Water Zero Sugar today.
This episode is brought to you by LinkedIn. Healthcare professionals can lead their careers with LinkedIn. Discover jobs by specialty, preferred shifts, and even desired salary. From mental health therapists to radiology technicians, it's now faster and easier for healthcare professionals to find the right fit. Learn more at linkedin.com/healthcare. Side effects may include faster job placement, improved work-life balance, and increased career satisfaction.
This is the plaintiff, Deborah Alter. She says the defendant's workers carelessly threw debris from the roof of the building they were working on and dented the hood of her car. There was no safety scaffolding, no nets, nothing. The defendant refuses to compensate her for the damages caused by his neglectful workers, and she's not going to be pushed around by anyone. She's suing for $1,356.47, the amount owed. This is the defendant, Joseph Vole. He says the plaintiff's claiming something fell off the roof of one of his buildings, but she didn't get out of the car at the time of the so-called incident. She drove away. 2 weeks later, she calls him with this bogus tale of woe, demanding he give her $1,100. This woman never filed a police report, never reported the damage at the time of the incident, and for all he knows, a tree could have damaged her car. He's accused of causing vehicular damages.
All parties, please raise your right hands.
Welcome back to the People's Court. Next case in the docket. The plaintiff says the defendant's crew threw debris from the roof of a building and damaged her car. But the defendant says the plaintiff is making it up. It's the case of, like McCarr says, don't give me any garbage.
Deborah Alter? Yes. You are suing Worldwide Properties, LLC, and Trumbull Company, represented here by Joseph Vole?
Yes, Your Honor.
Okay. For $1,356.47, $250 of it time from work for trying to get your money, and the rest of it for repairs to your car, because according to you, their negligence caused damage to your car. Tell me what happened.
So I went to the building at County Management Services in Trumbull to pay my common charges, maintenance fee.
Does he own that property?
Yes.
I'm confused.
Yes,
What
he
is
does.
it called?
It's called County Management Services.
And are they a government agency?
A property management firm that manages the condominium complex I believe she lives in, Your Honor.
Okay.
I paid it on that day, on June 12th. I decided to hand deliver it, left the facility, went back into my car.
And you were starting to tell me that you had just come from a funeral?
Yeah, I had just come from a funeral. The only reason that's relevant is because I was pretty upset. However, being in the neighborhood,
Whose funeral?
It was a close friend's daughter who was found dead in the house. It was pretty upsetting, and they do think that it was foul play.
Oh, okay, I'm very sorry. So, okay, go on.
So I was not in a great frame of mind, but within proximity of County Management Services where it was, I went to pay my common charges and left. Got back in my car, and all of a sudden I hear a loud bang, and the car shook, and I screamed. I then looked up, and that's when I noticed men working on the roof. Got out of the car, quickly looked around, didn't notice anything initially. I continued on my way, but puzzled why I'd heard this loud noise. And initially, as I said, didn't notice anything. I then went to my next stop, which was within minutes, went to a friend's house, pulled into her house, and she said, "What the hell happened to your car?" And we both looked at it. It was then that I noticed and observed significant damage to the hood of the car by the passenger side.
May I see the damage?
It's in here. Thank you. It looked like dents and scratches.
This is what you're talking about, right?
Yes, on the passenger side. This is a 2012
Passenger
Honda.
front?
Yeah.
If you heard a crashing sound that shook your car and you screamed, how did you not notice this?
Your Honor, that's a good question. I didn't notice it because of my frame of mind, having come from a funeral.
Well, then how do you know it happened there?
Because I made no other stops. I went within minutes of the accident.
Okay, so what did you do then? Did you drive back to the location and go and see the management people?
As soon as I noticed it, I called County Management Services and reported it.
Do you have a record of that phone call?
Yes. First 2 pages, sir.
Do you have a statement from your friend? Is that your friend with you?
No, I don't have a statement from my friend, Your Honor.
The one who you say noticed it?
Yes, we both noticed it.
You don't have a statement from her?
I do not have a statement from her.
Is this person moral support or a witness?
She is my daughter, and she is moral support.
Okay.
I immediately...
Did you call the police?
No, Your Honor, I did not call the police. I called County Management Services. They said that, yes, there were men working on the roof. I needed to contact the owner, their landlord, who would be responsible. I call Worldwide Properties that same day on June 12th. I get the answering service. This was about 5:30. It's in the log. I called them and got the service, didn't leave a message, called them again later that day, left a message with the service. I finally got a return call on June 13th from a girl named Sheila, identifying herself as someone from Worldwide Properties, stating on June 13th that she had spoken with Joe Vall, and he said to please fax an estimate of the damages.
So you did? And the estimate that you faxed him was for $1,300?
Yeah.
Or $1,100?
Yeah.
You were inside the car when it happened?
Yes.
And you felt the car shake and you didn't see? I mean, you know, do you understand the problem kind of with the story, right? You understand what my concern is, right?
I felt the car shake. Under normal circumstances, there's no way I would have missed the damage at the time. It was a close friend of mine whose daughter had died. My frame of mind was such that...
I don't need you to repeat yourself. I just, you know, like that doesn't mean... I understand what you were saying. It just makes me look closer at what you're saying.
Absolutely.
You understand? Let me hear from you. Go ahead.
What had happened was she had called into the office at a copy of a log that she did call in on June 13th. And I believe...
Now, you had said in your answer to the complaint that she called 2 weeks later. That's not accurate, right?
That's not accurate. Not call it 2 weeks. That's when we finally got a meeting.
That's very different. She called to complain of the damage 2 weeks later implies that you hear nothing for 2 weeks, which is way better for you in terms of how...
we had...
Okay, so you hear something right away. All right, so go on.
We had a call into... I checked the logs. We had a log in from June 13th, and we finally made contact with her on the 20-something of June. I had spoken to her, and I asked her, I said, listen, Deborah, what happened? Can you please explain to me what happened? So
did you have guys doing roof work?
No, because the roof was done several years ago, maybe about 4 or 5 years ago, the roof on the building.
Was there anybody working on the property at all?
Not on that date that we checked.
What about on the next date or the day before or the 2 days later or the 2 days before?
There could have been somebody working there a couple weeks later, like a week and a half or 2 weeks later.
But after everything?
After everything. What had happened was I said, listen, you got to understand. She explained to me that something fell on her car. She's not telling the truth. She told me, I said, well, if something fell on your car, Did you get out of your car? She said, no, I never got out of my car. That's what she told me. So she never got out of the car. I said, okay, you didn't get out of the car. So you're telling me, you want me to believe that something fell on your car, you didn't get out of your car in a good area. It's not a dangerous area. It's a very nice suburban area in the country. In Trumbull, you were paying your common charges, okay? Did you fill out an incident report with any of the tenants? There's psychologists on the first floor, there's accountants on the first floor, real estate office, travel agency.
Well, you can't file an incident report with the psychologist who rents from you.
No, but she would have reported it to somebody. She did no report.
She would have reported the police or the management office itself or something, right?
I got out of the car,
So she said she never got out of the car.
That's a lie.
I don't care whether you got out or not. I care whether you reported it. Go ahead.
I reported it that day.
So, is this a little suspicious on her part? That she drives away after she says she heard the debris hit the car and never complains?
It's very suspicious. You have to be able to see it actually happen.
But even if you don't see it, if you heard it, would you get out of the car and look?
Definitely. Otherwise, anyone can make such a claim.
And it may be what? I mean, what do you think is behind all of this?
It sounds suspicious. So maybe the damages were caused before or after the incident. And
Aha! I think you solved this one going inside the courtroom.
Do you have any proof that there were people working on the building that day? And that there was a dumpster next to you?
There was a dumpster to the right.
No, I don't want to hear you flap your gums. I asked for proof.
Well, what I have is a permit that was obtained from the building department, a copy of which reads, replacing the rotted siding on the building.
Let me see
Long
that.
Hill of Trumbull.
Right, but that...
However, it's dated
wait,
June
let me
the
see it. Let me see it. However what? Go ahead.
It's dated June the 20th.
Right.
And I don't understand how is it that I was there on the 12th witnessing
probably
work on
because
the
you
roof.
found out later they were doing roof work and that's why you're suing.
Actually, Your Honor,
so what are you suggesting? That even though the thing you pulled says that there's an issue date of June 20th for whatever work, and that's what he was saying, that there was work being done weeks later, you're saying that he did somebody who does pull a permit did the work first and pulled a permit later.
I say he had his grunts do the work first, and on the 20th, in retrospect, they obtained.
Why are they grunts?
Oh my God!
I'm sorry. I think
his workers might be a little offended by that.
I'm sorry. I don't mean
it's
that.
Honest work.
Jeez. What's frustrating? It's frustrating to me that I witnessed people working on the roof.
See, here's the thing, and it could very well have been their fault, but you have to come into a court of law and prove that it was their fault. And when you act like nothing happened, and then ask me to believe something happened at that moment and you're positive, even though you're acting like you're not positive, because you get out of the car, according to you, you look around the car and you see nothing, even though there's this big dent in the front of your car, and then you add to that the fact that work appears, according to the county, to have started several weeks after that.
I told him from the very beginning.
What am I supposed to do?
I noticed it almost immediately. I did not notice it at the site, but shortly thereafter, when I went to my friend's house, we both noticed it.
That's right. So you could bring me your friend, right? Where are you local? Where are we talking about? Where are you from, honey?
I live not too far.
Oh, very close to me. So your friend could be here and testify. Yes, it was seconds later she came and she told me she had just been, but I got none of that, right? I have none of that. I don't even have an affidavit from your friend, right? Mm-hmm. Okay, I find that there's insufficient proof in this case and I rule in favor of the defendant.
Well, unfortunately for the plaintiff, lack of evidence leads to a decision against you. So step in and what's your first thought about this?
Well, I'm very frustrated because there were no witnesses other than myself, and I actually thought it was an open and shut case.
Do you wish you had brought your friend in here?
Absolutely, yes.
That might have been a good idea.
Would have made all the difference in the world, yes. I'm frustrated. And lesson learned.
All right. You head right down there with Officer McIntosh, okay, please? And all right, so you step in here and put yourself in her shoes. What do you think happened here?
I think the judge made the right decision based on the facts. We tried to find any information that tried to help the lady. I had a witness ready to prepare to say she never got out of her car. That's not the information she gave me or the girl at the office.
You really think she was trying to pin some damage on you?
She told me when I spoke to her that she didn't have insurance or high deductible. Today, everybody's trying to get coverage when they don't have it. Okay. And they figured the deep pockets because the building owner possibly would get covered.
Over to Harvey.
You know, this is the case with car washes or anything else. If you hear something or you see something or you believe your car is damaged and you drive away, I'm telling you, you're going to have a mighty hard time proving your case. And that will do it for this case. Litigants for the next case on the way into the courtroom right now.
Hey, it's Paris. You know, I love sparkly things, right? Like stars. Duh. And thanks to Hilton and AutoCamp, I just slept under them. Picture me serving looks by the fire outside my luxurious Airstream, making s'mores with the kids, while a national park is our backdrop. The great outdoors meets Hilton hospitality. That's hot. Explore all the new ways to stay at Hilton.com. Hilton for the stay.
This is the plaintiff, Susan Romard. She says she agreed to rent an apartment from the defendant, gave him a deposit, and was all set to move in. Problem is, the defendant didn't own the apartment and had no right to rent it or take her hard-earned money. The defendant pretended to be someone he wasn't, and she's here to set the record straight and get the $4,434 she's owed. This is the defendant, Patrick Quick. He says he and the plaintiff entered into a contract to rent the apartment, and he made it clear she would be responsible for supplying her own heat. He also made it clear the deposit she was giving him would be non-refundable. A few weeks later, she called him and said she didn't want the place after all, and expected him to take a loss and refund her money. Well, he doesn't know what planet the plaintiff's from, but she must be a little loopy if she thinks he's going to lose money on her inability to make a decision. He's accused of pretending to be someone he's not. The defendant has filed a countersuit for $1,500 for defamation of character.
All parties, please raise your right hands.
Welcome back to the People's Court. Next case in the docket, the plaintiff says the defendant swindled her into believing that he owned the apartment, and now she says that she gave him rent money that she wants back. But he says he had an ironclad deal with a list of terms that bind her. It's the case of Swindler's List.
Susan Romard,
Yes.
you are suing Patrick Quick for $4,434 for criminal impersonation and fraud, pain and suffering, a deposit that you want returned. You are counterclaiming her $1,500 for defamation of character. Tell me what's going on.
Thank you, Your Honor. I went to view an apartment that Mr. Quick had on Craigslist at the beginning of September. I needed to move out of the apartment I was in for the last 4 years because my landlord sold the house. I had to be out by July 31st, and I saw the apartment and went to see it with a friend. I have a witness statement. She couldn't be here today. And looked around at the apartment, and then Mr. Quick stated that I may know his relatives because they're local. And when he mentioned who they were, I said, not only I know them, I've known them my whole life. I just didn't happen to know him. I know his mother very well, his grandmother. I actually used to work for his grandmother's sister for years and raised his cousin.
What were the odds?
Yeah, but I didn't know him. And I haven't seen his mom in about 30 years. So we chatted a bit, and one of my big concerns was moving into a place that I didn't know the homeowner. So he had somebody else, he told me he had somebody else to rent the place. The guy had the money and everything, but he didn't know him, and he had a 4-year-old daughter, so he didn't want a man that he didn't know there. So he wanted $1,500 down. It was $750 for the apartment, security, but I really wasn't looking to move until August 1st. So I didn't have...
And when were you looking at the apartment?
It was July 10th.
Okay.
Because usually when people post something online, it's for the next month. The tenant just moved out. So, but he said that he was in a fix because he hadn't been working, and so he needed somebody to move in right away. I said, fine, we'll work that out, but I don't have $1,500. He said that he needed to put in a floor before I could move in. So the next night, I had borrowed some money from a friend, which I have the paperwork for. I went there the next night. We signed a lease, at which point
Do you have the lease?
Yes, I do. On the 11th, and he stated on there that the apartment would be ready on...
Is the lease?
That's the lease.
Who wrote it?
He wrote it.
Okay, Susan Romard is renting apartment as of 7/11 on a 6-month lease. If tenant agrees to stay after 6 months, rent will continue on a month-to-month basis. Was this a basement?
No, it was not a basement.
Okay.
I actually do have a picture from Zillow of the actual house.
And it's what? It's a room in the house, or a room with a kitchenette in the house? What is it?
It's the side of a house.
Right,
It's
but
the
do you have your
house-
own kitchen, or don't you?
There's a 5-foot countertop with a sink. It stated that it only had a college-sized refrigerator, and I said I needed a real refrigerator because I have medication that needs to be refrigerated. But he actually doesn't even own the house.
Ending lease before 6 months results in non-refunding of security. Tenant deposited $850 on 7/11, and apartment will be ready for move-in by 7/13. Remaining deposit of $650 will be paid before 8/1. So did you move in on 7/13?
No, because the floor wasn't done, the apartment wasn't ready, and he actually had stated that he had a truck and that he would take the truck and he would come, and if I had everything boxed and ready to go, he would come and he would move everything out of my apartment. He would put it in, because I'm on disability, so I can't do heavy lifting. He said, I'll do that for you, then you don't have to pay anybody. And we were set for me to move in on July 14th. July 14th, when I called him, he didn't answer the phone. He didn't call me back. And he never called me back. And on Tuesday, when I called him, he said that his girlfriend had his phone, and he never got the message. And he didn't get paid on Friday, so he didn't do the floor, but it would be ready on the following Sunday.
Which would now be when?
The 20th.
Okay, so go on.
So when I called him on Saturday, the 20th, I asked him if the floor was done, and he said no. And he said that the reason it wasn't done was because that he was waiting for me to call him to tell him when I was moving in. And I said, no. I said, I asked you 3 separate times. This is what's going to happen. You're going to have it done. You're going to call me, correct? 3 times I reiterated. 3 times you said yes. You confirmed. So at that point I said, listen, I have to move in 11 days now. I would just want my money back. So I told him I don't have a place to go. I need that money back. And he said, well, you can't have the money back because I used it to pay my mortgage.
Okay, let me hear your version. What's going on?
On the 11th, I had a decision to make, the other guy or her. She begged me, because we knew each other, she begged me to let her move in.
So you picked her, and then you were supposed to have the place ready by July 13th. What happened?
Okay, so if the place isn't ready on the exact day that the tenant's supposed to move in, can the tenant break the lease?
It's her right.
It's her right, but what if it's like one day, just one day?
She has the right, but I don't know where she'd go.
One day, does she have the right?
Well, you got to go by the contract. If it was the other way around, then the other guy would have the right.
It's pretty harsh, going inside the courtroom.
I was supposed to have the place ready with paint, the locks, and cleaning up the apartment. As far as the carpet goes, she still had a remaining deposit to pay, which she said that she will pay on the 23rd when she gets her Social Security check.
Okay, you need to stop. That is not what your agreement says here. Your agreement here says very clearly she paid $850 on 7/11. Apartment will be ready for move-in on 7/13, and remaining deposit will be paid on 8/1. Okay?
The remaining before 8/1. It says
before 8/1. It doesn't say 7/23. It doesn't say that you don't have to have the apartment ready. Why wasn't the apartment ready? Answer the question I'm asking. Why wasn't the apartment ready on 7/13?
The apartment was ready. Keys, paint, cleaned, it was ready.
According to her, there was more that you had to do. What is that?
The flooring. It had tile floors. The apartment was clean, ready to go.
And what is it, according to you, hadn't been done on the 13th?
The floor was like a linoleum that was all ripped up. It was all ripped up, and he told me he had to put a new floor in. That's why he needed the $850 right away. And he stated that he had to do that. And I even said,
was the linoleum ripped up and was tile?
It has tiles, linoleum tiles. Is it ripped up?
Did you change a floor? Yes or no?
No.
Did you ever agree with her that you would change the floors?
No. The other thing, Your Honor, is he never gave me a key. So how could I move in?
How are you going to move in if you don't give him the rest of the money? I mean, what he's saying is you were supposed to give the rest of the money on a certain date and you didn't.
The 23rd.
Yeah, but why isn't that in your lease? If you say that that's what she had to do, the opposite.
My neglect.
But it's the opposite of what it says. Will be paid before 8/1. The 23rd is not before 8/1. That's 7-8 days before 8/1. Why would that be?
Right, that's before 8/1.
Oh yeah, so it's January, but she's not. See, for you to keep that money, you'd have to prove to me she's in breach. And you can't prove to me she's in breach. But there was something else that she said, that this isn't even your place. Whose place is this?
It's a family friend. He's my landlord.
Friend?
Yes, we've rented the house for 20 years.
Do you have the right to sublet?
My grandfather was in control after 15 years.
Do you have the right to sublet that place?
Legally, I don't know. It's my name isn't on the mortgage.
Okay. Does the landlord
I never said I'm her landlord.
Do you have an off button? Press it right now and listen to my question before you start barking. Listen. I need you to listen to the question because you don't even know what I'm asking you because you keep... Listen. You are leasing it from a person, right?
Yes.
And that person is a family friend.
Yes.
Does that person know you are subletting?
Yes.
Does that person give you the right to sublet?
Yes.
Is that in your lease?
No.
Can you prove that you have a right to sublet a place? Because you don't own it. So can you prove that you have a right to sublet a place?
I don't have paperwork stating that, no.
All right. Can you prove to me that she was in default because she was supposed to pay at a specific date before 8/1/13?
On 7/21, she called me and said, I can't take the apartment because it doesn't have heat. My doctors advised me not to take the apartment because it doesn't have heat.
Did the apartment have heat?
It says in the contract, supply your own heat, space heaters, oil, whatever.
What contract do you have?
All
utilities included except heat doesn't mean that there's no heat to be provided. That tells me I just got to pay for the heat.
Right, I'm not providing the heat.
Oh, there's no heat at all? Well, then I can answer the question about whether you can sublet it. The answer would be a big fat no, because the state of New York does not allow you to sublet apartments to people without heat. Did it have hot water?
I don't know. It didn't have faucets. He was putting them in.
How much money did you put down?
$850.
Why are you suing for $4,434?
Because I'm also suing him for criminal impersonation because he impersonated to me that he was the owner of the house. And to be honest with you, Your Honor, I originally had that amount at $850. But when they called me last night and they told me that he was suing me for slander,
you've got a counterclaim. Oh, wonder of all wonders. Wait a minute. Hold on. Counterclaim $1,500 for defamation of character. Explain that.
She called my landlord. She went to the village.
She called your landlord?
Called my family.
Why is that a problem?
Messages to my family.
Hold on. Why is that a problem that she called your landlord?
It's not a problem. But
then why are you counting that as part of your defamation case if it's not a problem?
Part of it is my family. She's called my family. She sent messages to my family.
And told them what?
That I stole her money. I'm a piece of garbage. Okay.
I mean, she's mad because you won't return her deposit. She doesn't understand why you won't return her deposit.
She called me on July 21st and said, I'm not taking your apartment because it doesn't have heat. Before we could even make it to the 23rd. There were space heaters in there that I told her I would leave her too. So they were in there, and I told her I would leave her.
Return the lady's $850. Verdicts for the plaintiff, $850. That's my judgment.
Your Honor.
So this arrangement does not work out very well for the defendant who has to return the plaintiff's money. So step in here. What's your comment coming out after
me, it's black and
case?
white. She didn't take it because it didn't have heat. In the contract, it says I'm not supplying heat. Black and white to me.
And the judge says the state of New York doesn't allow you to rent an apartment without heat.
I guess I got to take that into consideration.
Yeah, I think you might. It sounds like kind of a shady operation all the way around. An arrangement.
She begged me.
The arrangement between you and the real owner and the real landlord.
Nothing shady about it. My family's had the house for 20 years.
Doing this
from
for
the
a
guy.
long time.
20 years we've had the house.
First time you've ever had a problem like this?
First time.
All right, right down this way.
All right, guys, right this way.
All right, so step on in here. The plaintiff wins the case. You're shaking your head over there like what? What?
It was an illegal apartment. His landlord didn't even know he was renting it. When I called, that's why he was mad. I called the landlord. He didn't even know
it was an illegal apartment?
No. He didn't even know there was an apartment in it. The landlord said, there's no apartment in there. This man has got major character defects, major. And I never begged him. His mother called me. His family called me.
Okay. Harvey?
There's something that every state has, which is called a warranty of habitability, which is implied in a contract, which means it has to be a safe place to live and habitable. The heat is a critical part of a contract. The tenant can't even waive the right to heat. A landlord has a duty to supply heat, period.
ABC Wednesday, Shifting Gears is back.
He has arisen.
Tim Allen and Kat Dennings return in television's #1 new comedy.
What?
With a star-studded premiere including Jenna Elfman, Nancy Travis, and...
Hey, buddy!
A big home improvement reunion.
Welcome.
Oh, boy.
That guy's a tool.
Shifting Gears, season premiere Wednesday, 8/7 Central on ABC, and stream on Hulu.